The U.S. has made great strides since our environmental laws were enacted in the late 1960s and early 1970s, but we are only one half of the way to the goals Congress set in 1972 for fishable and swimmable waters, and that goal was to be met by 1983. With much work remaining to improve water quality, the Trump EPA appears determined to roll back water quality protection wherever possible. To date, EPA actions include reducing the scope of waters protected from pollution and destruction under the Clean Water Act to levels not seen since the Clean Water Act was enacted. Just last week, EPA finalized a rule to return the scope of waters protected to those established by the Reagan administration. This is directly contrary to the position of all interest groups following the confusion generated by the Supreme Court, and that point was made quite eloquently by the chairman of this committee. I was on the staff of this committee at that time, and I can tell this committee that no one argued to retain the status quo. Some argued for regulation, some argued for legislation, but nobody asked for the Reagan-era rule, yet that is the course that the Trump EPA is pursuing. Even more detrimental to water quality, EPA is finalizing a rule that, as proposed, would further weaken the Clean Water Act by eliminating protection for thousands of stream miles and wetlands nationwide, including 55 million acres of farmland containing wetlands, an area roughly the size of Nebraska. The proposal was clearly based upon Justice Scalia's plurality opinion in Rapanos, which 5 justices rejected. And notwithstanding what Mr. Ross said about the concurrence of Justice Kennedy, Justice Kennedy called the Scalia opinion unpersuasive and, quote, inconsistent with the Act's text, structure, and purpose, close quote. While there's been a lot of discussion about the proposal providing more clarity, I would argue that it provides far less clarity. If a landowner is supposed to know what is or is not covered on their property, I can read you some of the language that is in the proposal, saying that landowners will have to rely on trapezoidal flumes and pressure transducers for measuring surface flow and comparing that to rainfall, that they will need to do regional regression analysis or hydrologic modeling, that the rule itself admits will be challenging to accomplish in the field and could be time-consuming. That is from the proposal. In developing the Clean Water Rule, EPA's Office of Research and Development prepared an exhaustive synthesis of peer-reviewed science on how waters are connected. EPA has made no attempt to refute the science. Instead, EPA chose to ignore it. EPA ignoring science is like the CIA ignoring intelligence or NOAA ignoring weather forecasts. EPA is reconsidering the steam electric effluent limitations guidelines. These controls would annually eliminate 1.4 billion pounds of arsenic, lead, mercury, cadmium, selenium, chromium, 30% of all toxics discharged by industry in the United States, as well as nutrients from our waters. EPA is doing so even as the Fifth Circuit Court of Appeals ordered EPA to consider stronger controls on discharges, not weaker ones. And I would also point out that Mr. Ross earlier, in answer to a question, seemed to not want to answer on the coal combustion residuals rule, known as CCR, not Creedence Clearwater Revival. But that rule is also under reconsideration at this point. So the agency is currently in the process of relaxing the requirements for water discharges while simultaneously reviewing the rule that would have controlled the existing impoundments, the very issue that the Fifth Circuit told EPA to look at. The EPA is allowing greater amounts of pollutants from treatment plants through blending. Make no mistake, this is a reduction in the secondary treatment requirements that Congress wrote into the law in 1972. We've already heard about EPA reversing its positions on Section 401. Ms. Bellin explained very clearly why that is so important to the states. Mr. Ross himself acknowledged that these permits can take 4 to 5 years, yet he would propose to cut off a state's action to act on that permit in year 1, when the state doesn't even know what the project is that it needs to protect its water quality from. The Trump EPA is systematically taking the cops off the beat by significantly reducing its ability to enforce environmental protection laws through budget cuts and reducing the actions it takes. These reductions are a conscious decision to create more avenues for our bedrock environmental laws to be violated without fear of being caught or responsibility. Candidate Trump promised to get rid of EPA in almost every form, leaving, quote, little tidbits intact. This may be in the interest of developers, oil and gas, agribusiness, and significant polluters, such as coal-fired plants, but it's not in the interest of the public or the environment. In my 34 years of water law, I have never heard the public say that the water in our rivers, lakes, and streams and ponds is too clean, that there are too many healthy fish to catch and eat, that our drinking water is too clean, or that we need more beaches to be closed due to pollution. EPA needs to do its job in protecting human health and the environment under the Clean Water Act. This is not a time for retreat. Thank you.
Thank you, Mr. Kopocis.